Please, Your Lordship.
Yes.
Lordship, I beg to mention hearing item number 18, Your Lordship. Item number 18, Lordship. Lordship, this is a part-heard matter. However, Lordship, my senior Mr. Inti Longjem, he's
okay.
not well.
Release from part hard.
Or
It's
Lord,
always better.
or it can be listed when this bench will
yes,
be
but in the
available.
meantime, we'll release from part hard. Nah? You're for?
Lordship, I'll leave it to you.
You're for
Respondent number 3, Your Lordship.
Respondent number?
3.
Okay. You're for? Okay. You have no objection? Okay. Yes, yes. Mr. Counsel for the petitioner. And Miss
Lucino for respondent number 3, Lordship.
Counsel for the respondent number 3.
3, Your Lordship.
Okay. So prior to that, no. So please name, huh? 1 for 1 and 2, huh? Okay. So the line counsel for the respondent pray for listing this matter after.
Lordship, if Lordship will allow, if it can be listed in Your Lordship's court the next time this bench is available. If it can be kept as part heard and
part heard. No, we'll release from part hard, but it will come to my court only if you want. Yeah.
Okay.
So, but then we'll release from the part hard. So after, say 4 weeks.
It will become a recurrent task to restart from the beginning again. Because it's a lengthy.
No, it's not proper to keep the things part hard for such a long time. So in view of, okay, please matter after 4 weeks. Huh? Okay. The case stands released from part hard. Okay. Then list is after 4 weeks. Okay.
May I please, my lord?
Yes.
Lordship, item number 14, 1-4, Lordship. Lordship, here I'm yet to receive instructions. So can you grant me 3 weeks time, Lordship?
Okay. Here for the petitioner.
I will bring on behalf of Abi Signature, the counsel for the petitioner.
Okay. You are also praying for time. Appearing. Okay, Mr. Appearing on behalf of Mr. Abi Senator Su. Mr. Appeared on behalf of Mr. Senator Lani counsel for the petitioner. Stop. Mr. Angami Lani counsel appearing on behalf of the state respondent.
Lordship.
Praise for how much time?
3 weeks, Lordship.
3 weeks time to obtain instruction and to file affidavit. The prayer is allowed. List this matter after 3 weeks.
Or interim order.
The interim order passed earlier shall continue till the next stage. Okay.
Lordship.
May I please, Your Lordship?
Yes.
My Lord, I beg to mention item number 3 to 6. My Lord, kindly grant 2 weeks to file affidavit in reply to the counter file.
Yes, in this case, you are yet to file affidavit in reply.
Yes, my Lord.
We'll pass order. Instead of mentioning, we'll pass order because you are yet to file affidavit. Okay, you are Miss
K. Christina.
Counsel for the petitioner. How much time you are praying for?
My Lord, 3 weeks, my Lord.
Praying for and is granted 3 weeks time to file affidavit in reply to the affidavit filed by the respondent. Stop. Mr. Angamilana, counsel for the state respondent, is also present. List this matter after 3 weeks.
My pleasure. I'm appearing on behalf of Advocate Sandy Younger. And I beg to mention item number 2. This matter may be fixed on Thursday. This matter fixed on Thursday, 2nd May. As we are on the
why not today?
Lordship, we are in the process of negotiating. We are in the process of negotiation.
Negotiation? This is a criminal petition.
Yes, Lordship.
The quashing petition or what?
Yes.
Yes. Negotiation with whom?
My learned friend, not all the details since he's representing, appearing on behalf of Mr. Younger. What is so?
Oh, younger,
Sandy Younger.
Sandy Younger is not present.
Yes, yes.
Okay. So I think you might have brought the status of the case also. No.
No, not sure.
Okay. Mr.
Moklai and
appearing on your name is also there.
no lordship.
Okay, appearing on behalf of
The Younger.
Mr. Saint Younger, Land Council for the petitioner. Praise for listing this matter on
Thursday.
Thursday
For admission hearing, my lord.
for admission hearing. You are for?
I'm for respondent number 2.
Okay. Mr.
Akam Zamir.
Okay. Angami Land Council, Land PP. And Mr.
Akam Zamir.
Land Council for the respondent number 2 are present. Okay. As prayed, come on, list this matter on Thursday.
Fixed on Thursday.
Okay. For admission hearing. Huh?
Obliged.
Yes.
Lordship, I beg to mention item number 16, Your Lordship.
16.
The leading counsel is from Gauhati, and he's in bereavement, Your Lordship.
This is in the order column only.
Lordship.
We'll see and pass necessary order.
Okay.
Okay. You be there? Okay.
Lordship.
Let's
Yes.
Lordship, I'd like to mention item 10.
Item 10.
Item 10, yes. Item 10. I'm representing the state here, Your Lordship. Allow me.
Affidavit not yet filed.
No. I'm seeking for instruction.
Okay.
So allow me 3 weeks time so that I can obtain instruction and file contract, state contract.
Okay. Mr. Zamir, Land Council for the petitioner is present. Mr. Muayyim Chen, Land Senior Government Advocate, praised for 3 weeks time to obtain instruction and to file affidavit. Stop. The prayer not objected. Release this matter after 3 weeks. Okay.
Obliged, Lordship. Lordship, I'd like to mention item 9 also. It's a contempt petition, Your Lordship.
Yes.
So the contempt petition, and then the procedure is in the false way for consideration of to comply with the contempt petition. So therefore, I seek 2 weeks time, Your Lordship.
3 weeks.
So that
You
I
are
can
for
be able
respondent number
Item number 9. I am for respondent number 1.
1.
Your Lordship,
Yes.
here, Your Lordship, on the last occasion, the states were granted 45 days to comply with the court order. And until now, it has not been complied, Your Lordship.
Lordship, this pertains to regularization.
Okay.
This pertains to skill upgrade, Lordship.
Scale of pen.
So now, there is a process to be followed. File has to be routed to the department, and then from the department, it has to put it to finance. It has to put it to cabinet again.
So you are praying for compliance.
Yes.
Okay. You are for respondent.
Lordship, I'm going for respondent number 3.
Three.
Lordship, respondent number 3 is already retired, and a new principal
Okay.
director has been taken place, Lordship.
Probably affidavit also filed. No.
Yes, by respondent number 3.
Okay.
So in
The
view of the retirement, Lordship, the new incumbent is necessary to be employed in the petition.
okay. But then I think the earlier one has already
It will
filed
remain.
affidavit.
It will remain.
Okay. He has already filed affidavit, I think.
Yes.
No.
Lordship.
Yes. Yes.
Respondent number 3 filed affidavit.
Hmm.
However, in view of retirement, Lordship, the
Need
new
to
incumbent
replace.
is necessary to be
Need
employed.
to implement the new income.
Yes, Lordship, for that, I will
Okay.
file amendment by.
Are you also appearing, Mr. Zimo? Respondent number 2. Okay. Mr.
Subhamati. But your lordship,
Supomati Waling.
if I'm allowed, your lordship,
Yes.
on the last occasion that is respondent to, that is the financial commissioner, your lordship. In their affidavit, they clearly stated that they are taking all the necessary steps to comply. And then accordingly, this honorable court have granted 45 days to take all the necessary works, your lordship. But
Yes.
until now, this has been pending. So if they are seeking for 3 weeks, I don't have any objection, but then this 3 weeks be the last chance, your lordship.
Okay. One for two. Okay.
Mr. is for, my friend is for respondent number one, that is Commissioner and Secretary, PNR Department, Personnel and Administrative Resource Department.
Mr.
Representing the
Okay.
Financial
So
Committee.
both are praying, Mr. Okay, Zimomi Learning Council for the respondent number two and Mr. Sorry, respondent number one and Mr. Mohammed Learning Council for appearing on behalf of the respondent number two, prays for further 3 weeks time to comply with the order and direction of the direction of this court. Okay. Mr. Suponcho, Walling, Land Council for, no, Mr. Huh?
What is it?
Land Council for appearing on behalf of the respondent number three, brought to the notice of this court that the respondent number three, during the pendency of this case, the petition, the respondent number three has retired. Okay. Mr. Supomati Walling, Land Council for the petitioner also prays for some time to complete the new
Principal Tariq. Principal Tariq.
Okay, incumbent. The respondent number three is, who is the respondent number three?
Principal Tariq reserves in account.
Okay, so the new incumbent principal.
Principal Director.
Okay, principal
Research.
director. Okay, that's management. In view of the above, list is made after 3 weeks. Okay. Okay.
Okay.
Please, your lordship.
Yes.
Your lordship, I beg to mention item number 11 and 12. Yes, state is yet to file affidavit, your lordship.
Yes.
So kindly grant me 3 weeks time.
Mr. Supamati Waling, Land Council for the petitioner is present. Miss
AIME,
Land Council appearing on behalf of
state
the
respondent.
state respondent, prays for further
3
3 weeks time to file affidavit in opposition. Stop. The prayer is allowed. List is matter after 3 weeks.
Much obliged.
11 and 12, huh?
For admission, item number 1.
Yes, your lordship. Lordship, today I have some difficulty, lordship. So if this matter can kindly be listed after 2 weeks, your lordship.
Okay. Miss Luzino, Land Council for the petitioner, expressed some difficulties today and prays for listing this matter after
2 weeks, your lordship.
after 2 weeks. Okay. Mr. Zimomi, Land PP is present. Is present. And he has no objection. There is no objection. Stop. He is prayed. List this matter after 2 weeks.
Highly obliged.
Okay.
For admission, item number 7. In this case, the state has already filed the affidavit.
Already filed.
Yes, Lord.
Okay, so in the record, affidavit in opposition not filed, it appeared. That means
The railways, especially the Union of India and the General Manager, Northeast Railways Fund, they yet to file the affidavit, Lordship.
okay, 1, 5, 6, and 7 are yet to file.
Yes, Lord.
Okay, the state has filed.
State has already filed.
So who appears on behalf of respondent number 1, 5, and
Lordship, I'm appearing on behalf of my senior, Young Gauhati, CGSA. Lordship, we're yet to receive instruction. Yes, 1, 5, 6, 7, 8.
okay?
1, 5, 6, 7.
So when will you file? How much time?
3 weeks time, Lordship.
3.
Yes, Lordship.
Mr. Muazami, Land Council for the petitioner is present. Miss,
This is Nokiso.
appearing on behalf of Yangarbati, Land CGSC, submits that they are yet to receive instruction and prays for 3 weeks time to obtain instruction and obtain necessary instruction and also to file affidavit. Stop. Mr. Your 4 respondent number?
2, 3, 4, and 8.
Mm,
2, 3,
is
4, and 8.
Also, on behalf of the respondent number 2, 3, 4, and 5, 4
8.
and 8 is also present. Stop. Is prayed. List this matter after 3 weeks. Okay.
Much obliged, Lordship.
For admission, item number 8.
For washing of FIR, Lordship. What has happened while painting this, Lordship? I have given the instruction to my client to withdraw from the case, Lordship. There is no cooperation from the client, Lordship. So I have communicated a letter to my client, Lordship. And to that effect, Lordship, I filed an affidavit this morning. If this matter can be listed after 2 days so that necessary orders may be passed, Lordship.
On Thursday
Lordship,
or Friday. Okay.
at the convenience of this honorable court.
Okay. No, please. Okay. Mr. Muazami, Land Council for the petitioner, prays for listing this matter. When?
Convenience of this honorable court, Thursday or Friday, Lordship.
Okay, on Friday, huh? Miss,
Mika Chair.
and
Correspondent number
Mr. You for respondent number
1, Lordship.
1, and Mr. Jimami, 4, respondent number 2 are also present. So please pray to list this matter on Friday.
Obliged, Lordship.
Will not say anything, huh?
Lordship.
Okay.
For admission, item number 13.
So the state has already filed affidavit here.
No, Lordship.
State not yet filed.
No, Lordship.
Who has filed there?
What's my filed?
On behalf of respondent number 2 and 4.
3 and 4, Lordship.
Okay, 2, 3, and 4.
Lordship, I'm representing the Union of India Mode as well as NHIDCL, Lordship. I'll file my affidavit.
Okay, so what about the other respondents? State 2, 3, and 4.
State, not yet filed, my lord.
Lordship,
Not
I'm
yet
still yet to file since I'm waiting for instruction, Lordship.
Okay.
My lord, on the last date, I prayed before this honorable court to dispose of my representation to carry out the assessment.
Okay,
And this honorable court obliged to hear my prayer on this date.
okay, you have submitted representation and then
On page, necessary 3, page 25.
is it okay
Lordship, I
to
don't have,
direct the state to dispose of the representation?
Lordship, I don't have any objection.
Okay. You have any grievances against this respondent number 2,
Second.
3, and 4?
As of now, my lord, my representation may be disposed of as of now to carry out the
Okay.
assessment,
Okay,
which is to be done by the respondent number 7, which is the deputy commissioner.
okay, so 2, 3, 1, 2, 3, 4, 5 not connected.
Yes, my lord, as of now.
Okay. Heard, Mr.
Okay, so my lord.
And counsel for the petitioner. This is item
13, Lordship.
13. Oh, no. Also heard. Mr. So who represent for one? You are for one.
Yes, one,
Okay.
5, 6, 7,
Okay.
and 9. State.
Representing
One,
respondent
5,
number 1,
6, 7, 8, 9.
1, 5, 6, 7, 8, and 9. And Mr. Muazzamir, appearing on behalf of respondent number 2, 3, and 4 staff. Your grievance is
My property is badly damaged, my lord.
Hmm?
My property was badly damaged. My farmland. The respondent number 7, all the respondent, especially the contractor, have dumped all the waste on my plot.
by filing this petition under section, filing this petition under Article 226 of the Constitution of India, the petitioner seek a direction for payment of compensation for damage caused to
my farmland.
The petitioner's farmland located at DEF Colony, Junebato, by the damage caused by
Contractor, my lord.
contractor at the time of construction of two-lane from Chakabama to Juniboto under SARDP Phase A, which was executed by the Gauhati Project Limited. Staff,
My lord, as first the contract was executed by the country, but in the year 2011, NHIDCO was awarded the contract. NHIDCO was awarded the contract to carry out the NHIDCO.
Lordship, I'm representing NHS
In the number-
in this case, Lordship, as well as the more the ministry who sanctions for this construction of this land.
Okay, where specifically you have mentioned that the replacement and all those?
On Pera 2, my lord. On Pera 2, my lord. On page 6.
Issues of the between the company and the government of India, the same work has been awarded to, okay.
My lord, it may be also be reported that it is a fresh damage. Freshly damaged. After the work was awarded to the NHIDCO.
So thereafter also it was damaged.
Yeah, it was damaged.
So your claim is against this Gayatri project or for and both or only with only against the DCL?
NHIDCO, my lord.
So not against Gayatri
Gayatri.
project? No.
Yes, my lord. As of now, my lord, my only prayer is to carry out the assessment, which will be carried out by the respondent number 7, Deputy Commissioner.
Where is your representation?
On page 25, my lord, the next 3.
Okay, leave that. Now, the petitioner by filing this writ petition is agreed by the two-lane construction from Chakabama to Junevoto under SARDP Phase 1, Phase A executed by the Gayatri Project Limited, which began in the year 2011 by the said company, but due to issue between the company and the government of India, which later on was awarded to NHIDCL. What is the full form of NHIDCL?
National Highway Infrastructure Development Corporation Limited.
Okay. In short, NHIDCL, staff. The grievance of the petition is that the petitioner is also aggrieved as her complaint representation dated 27/7/2023 praying for conducting assessment of the damage caused to her farm situated at DEF Colony, Juneboto, was not considered by the respondent, more particularly respondent number 7.
Yes, my lord. I've also served representation to respondent number 4, Executive Director, and
Respondent number 4 and 7. Respondent number 4 and 7.
Yes, my lord.
Okay, start. The land counsel for the petitioner submits that since he has a limited prayer to against the respondent authority to dispose of his representation submitted when
On 27/7/2023.
and this was before 27/7/2003 before the respondent number
4 and
7
7. On the 7th,
And-
I've submitted to both the respondent.
on the same day.
Yes, my lord.
Okay, respondent number 4 and 7. This writ petition can be disposed of with the direction to the said respondent to dispose of his above representation submitted before the respondent number 4 and 7 staff. The land counsel for the respondent, both the land counsel for the respondents has agreed, has no objection if this writ petition is disposed of with the direction to, with the direction is prayed for by the Land Council for the petitioner staff. In view of the agreement by the Land Council for the party, comma, this writ petition is disposed of with the direction to the respondent number 4 and 7 to dispose of the representation dated 27/7/2023 submitted by the petitioner by a speaking order. Stop. The by a speaking order within a period of
1 month. 1 month.
30 days from today. Okay, stop.
Sorry for indulgence, if my submissions may be recorded, because there is a contention raised against the energized lordship. Para 2 of the writ petition, it says that the damage was caused by the contractor, the principal contractor, Midas Skytree lordship, and it was in the year 2011 lordship. NHIDCL lordship, we have filed an affidavit and categorical statement has been made at paragraph 2 and 3, stating that we came in the picture only in the year 2017 lordship. Mode has entrusted us to complete the project.
So that you say probably that this authority respondent number 4 and 7 knows this, I think, this fact, and while disposing of the representation, they will just.
If my submissions can be kindly recorded.
Okay.
That we came in the picture only in the year 2017, and the claim made at paragraph 2 of the writ petition is in the year
prior
2011.
prior to the last one, huh? No, after no objection, huh? With no objection, huh? So, our Mr. Muaz Jamilane, counsel for the respondent number 2,
3 and 4.
3 and 4 submits that the respondent submits that the what is your this one?
The work was awarded in the year 2011 to Midas Gauhati lordship. It is mentioned at paragraph 2 of the
No,
petition.
you are representing
2, 3 and 4 lordship.
the 2, 3 is
2
and
is
4 is
Mode lordship.
NHI.
Yes, 2 is Mode, the ministry. 3 and 4 is the NHIDCL lordship.
Okay, so but then 2. So the
NHIDCL.
NHIDCL
Yes, Lord.
came into picture only
In the year 2017.
in the year 2017.
More particularly on 14 February 2017. That was a communication entrusting us to execute the balance of work. Lordship.
Okay. After the damage was already
Yes,
caused.
Lordship. Yes, Lord.
After the damage was already caused. Huh? Okay, be that as it may. Huh? Then since the party has agreed, that will come. Huh? Okay,
Lordship.
Within 30 days, huh?
Lordship.
Copy also be copy. Then you present the copy before the authority. Okay, certified copy of the order. Okay. With the above, this petition stands disposal. Okay.
For admission item number 15.
Yeah, 15. This is 15.
Lordship, last mention, case study was called for.
This is bail application only.
Yes, Lordship. And I've been informed that the case study has been received.
Whether the CD was called for.
Yeah, it is received, Lordship.
Received.
A scanned copy of the CD has been called.
So, Lordship,
Okay.
I've received.
before your Lordship bears the CD, I mean, we allowed 10 minutes, Lordship, to place my case, Lordship. How the transaction between the petitioner and the complainant was made,
Yes.
On what basis the FIR was lodged and the arrest of the present petitioner, who is under custody for 69 days, Lordship.
He has been in the inside 69 days.
Yes. I was arrested.
What is the maximum punishment? 90
Lordship,
or minimum?
409 is imprisonment for life,
Okay, then 90.
and 420 is 7 years.
Okay. Then it's okay.
Lordship. Lordship, petitioner is the CU, the provider of a Gauhati gold sparse the remain, Lordship. Under
Professor.
provider
Hmm.
of sparse entertainment, Lordship. What even, Lordship, in the year 2021, the complainant
Yes.
complainant and the petitioner can do know each other. And Lordship knows that the present petitioner is dealing with the supply of equipments of camming machines and installations all over India, Lordship. So whatever, Lordship, the complainant placed an order of a camming machine equipments through the present petitioner, who is the CEO of the company, Lordship. And in order to supply the equipments, Lordship, an agreement was executed between the petitioner and the complainant to the effect that 50% in advance should be paid to place the order.
Agreement to reduce into writing?
Yes, Lordship. I'll refer
You
to
have
that.
annexed?
Yes, Lordship.
Okay.
The agreement is executed 50% in advance and 50% before shipping the equipments. Admittedly, Lordship, even in the complaint also, the complainant stated that he paid 55 lakhs to the present petitioner for the total cost of machine equipment of 70 lakhs. So accordingly, on payment of 55 lakhs, the present petitioner have paid a set amount to the manufacturing company in China. However, Lordship, till date, 15 lakhs is not paid by the complainant. And therefore, Lordship, the manufacturing company, in view of non-payment of the full amount, the machine could not be delivered till date.
So the rest of the amount was to be paid at the time of delivery or
before delivery?
Before delivery. During the shipment.
Yes, Lordship.
Hmm.
Once the full amount is paid, Lordship, the petitioner is ready to supply the camming machine, which is to be transported from China, Lordship. However, Lordship, what happened? An affair was lodged before.
No, where is the agreement when it says that it has to be paid?
Lordship, me kindly turn to page 12.
Hmm?
Page 12 of my petition.
Page 12.
I've indexed only the relevant portion, Lordship. Sparse entertainment. And this is the signature of the complainant Atuka Sumi, Lordship. First page. Page 12, Lordship. And page 13, Lordship. There is no dispute at all with regard to this agreement. Terms and condition. Number one, payment terms 50% advance, 50% before shipping from China, Lordship. Am I clear, Lordship?
Yes. So where is his signature?
Signature in the front page, Lordship. Front page. As well as in the second page down below, Lordship. Dr. Atuka Sumi. No, am I clear, Lordship?
Okay.
Lordship, come to FIR. Page 16.
Yes.
I'll take your Lordship attention to the relevant portion only. Paragraph 4. That accordingly, condition for granting equipments was sent to me on so date, and after much assurance, In order to expect the project, I place an order for purchasing the camping equipments with rupees 70 lakhs. The cost of the machine is 70 lakhs, Lordship. Next paragraph, page 5, Lordship. Paragraph 5, Lordship. Next page. Not in order to abide with terms and condition. It is reflected here also, Lordship. Amidst first entertainment, I agreed to make the payment of 50% as advance and remaining 50% at the time of delivery.
At the time, now he's saying at the time of delivery of equipment.
That is his complaint. This is a complaint, Lordship. And next page, Lordship.
Now, yes.
Lordship, paragraph 6, not next page. That it may be noted that both after made an assurance to supply the said camping equipments, immediately after adhering to the above mentioned terms and conditions, shipping up camping equipments within 45 days from the date of payment of 50% at advance and 50% after delivery. That is wrong, Lordship.
No, so it says that is after delivery.
Yes.
How much total she paid?
It is written here, Lordship. I have paid more than 80% of the payment, that is 55 lakhs.
Yes.
Out of 70 lakhs. So the complainant has to be 55 lakhs more, Lordship. 15 lakhs, Lordship.
Now, have you replied the legal notice?
I have not received the legal notice.
And then the legal notice, when it was sent to the address given by you.
I have not received the legal notice. I have taken the ground in my bail application.
That also return no such person in the address.
I don't know, Lordship. Otherwise, I'm the CEO of the company.
Because if it is a company, and he probably he or she,
Lordship,
has also visited the company.
Yes, Lordship.
So, but then when he sent the notice, it returned no such person in the address. So,
I don't know what happened to his legal notice, Lordship. I have not received. But the Lordship admitted fact that the complainant has to be 15 lakhs for the cost of the equipments. And once he paid to 15 lakhs, I'm ready to deliver the camping machine, Lordship. And Lordship, one last back of the matter, Lordship. The money which the complainant paid, that is 55 lakhs, has been.
Now since the case has come up, he also lodged FIR.
Yes.
And then he made some payment around 50 lakhs.
55 lakhs.
55 lakhs.
Yes. That money has already been transferred to the manufacturing company, Lordship. I've enclosed the transaction records.
Now, according to the agreement also, as you said, that the equipment must be on the way, must have reached India.
No, Lordship. As in when the full payment is made, thereafter only the company will.
No, the 50%. No, the 50%. The rest of the amount is to be paid before.
That is an advance for placing the order, Lordship.
So during the shipment,
the purpose of placing the order, I made a payment of 50%, Lordship. There is no dispute about the transaction, Lordship. The complainant paid 55 lakhs, which the petitioner subsequently paid to the manufacturing company, and the complainant has yet to be 15 lakhs for the cost of the machine, Lordship.
What type of agreement is
the equipments and the.
This is you see the payment on this agreement also is what type of this agreement is? The 100% is to be paid before delivery. How it is possible?
Yes, Lordship.
Now, how it is possible?
But the agreement is very clear, Lordship. 50% in advance and then 50% before shipping the equipments from China.
And you have also
it is not from India, Lordship. It is from China. The manufacturing company is based in China, Lordship.
See, just payment terms, 50% advance, 50% before shipping from China. So both are advance or 100% is advance only. 50% advance.
Yes.
50% before delivery. It's all the same. It's advance only. What
Fifty
type
percent
of
is for the purpose of blessing the altar, lordship.
So if you can understand that if, during the shipments, if it ensure that it enter India, then at that time before delivery can pay, payment can be asked for. But then 50%,
No, it
100%
was
before,
directly delivered from China, lordship.
now also you see, it's been almost 3 months. So why don't you deliver?
The petitioner is in custody, lordship,
Hmm.
and the remaining balance of 15 lakhs is yet to be paid, lordship. Until and unless the remaining balance is paid, the equipment should not be delivered, lordship.
Now that means you are still ready to deliver.
Yes, lordship. Once the balance amount is paid. However, lordship, after filing a FIR on a false allegation of cheating, lordship, the
Yes,
petitioner was arrested.
what is there? Hmm.
As per the terms, it is 50 advance, 50 once the consignment reaches. That is at the delivery, Your Lordship.
No, no. So
Now,
you have
80
seen-
lakhs has been paid, Your Lordship.
No.
Mhm.
80% has been paid, Your Lordship.
Yes.
A part of the complaint has been read out. Your Lordship may kindly turn to page
That is
18.
the
Your
complaint,
Lordship.
lordship. That is the complaint.
FIR
Para
18.
8. Para 8.
Here are 8.
Yes.
Yes.
May I read, Your Lordship?
Yes, please.
That as such, I inquire from them as to when the delivery of the equipments will be made. To these, they invariably give assurance that the cargo shipment has left China on 7/1/2023, and that there will be 2 trucks on this shipment, which will reach Dimapur, Nagaland by the end of July 2023. Your Lordship, however, the said assurance turned out to be false with no such delivery made. Therefore, on several occasions, I contacted both of them, but on one pretext or the other, they would make excuses that either the consignment were in Mumbai, waiting for the shipment, or in China to make the shipment order, or at time inform me that they cannot attend to my calls due to poor network connections when in China. It thus become obvious that they had no intention of delivering the equipment. A perusal of some of the communications between us would show that there was a deliberate attempt being made to mislead and hoodwink me. This is apparent from the fact that I was made to direct all inquiries from one person to the other, and is apparent from the WhatsApp conversations and messages that took place between January to November 2023. Your Lordship, this was 2023. Now, CD has come where it's shown that prima facie, the petitioner is prima facie case under section 409, 420 has been
No,
established.
just,
Your Lordship.
this is allegation in the FIR only.
It is on
Just-
the straight, yes, Your Lordship. on
Just see. He is alleging that he sent a notice
Lordship,
in return, whether the police has collected the return notice.
return notice of
Has the police seized the return notice that the person, no person is such in a given address
that, Your Lordship, I'll have.
did
to
not
seek.
seize?
Your Lordship, I'll have to seek.
And then what is the statement?
Yes, Your Lordship, the
Or-
statement is at page 10, Your Lordship, of the accused. Page 10.
No, statement of the applicant, sorry,
The complainant,
informant
the informant
about the agreement.
about the, Your
whether
Lordship,
he-
first page.
Hmm?
Atoka Asuli, Your Lordship. Name of the complainant.
Yes.
Atoka Asuli.
So what he has stated about the
Your
agreement.
Lordship, here, his statement is recorded, Your Lordship,
Hmm.
under 161. So, Your Lordship, it is clear that 50% payment was to be made in advance, 50% at the time of delivery, Your Lordship.
No, the what, has he stated anything about the execution of the agreement that 50% after they be at the time of placement order and
They have made
50% before
mutual
delivery?
agreement with the company, Your Lordship, at Maharashtra.
Condition. Equipment will be delivered after 45 days. Maybe. Now just kindly see,
Your Lordship.
he has here also stated
Yes.
two things I just want, if you could find
Lordship.
from the
CD.
CD.
Yes.
One is that whether the agreement executed by the informant and the accused has
Yes.
been seized, because himself has also stated, because 50% was to be paid advance,
Advance.
and then the rest of the 50% later on.
Yes, Your Lordship.
Okay, but then here also he did not pay 50% alone. He paid 80%.
80. Yes.
80%.
Lordship.
So that means it is presumed, unless he agreed that that he also agreed that it was to be 100% to be paid before delivery. Why otherwise? Why he should pay 80%? He paid 80%.
Lordship.
Now 85. 15% remain.
20% remain.
80 or 85?
80%.
80%. Then 20% remain.
Yes.
So 20%, according to them, he has to pay this 20% also in order to
According
to
to
bring.
them,
Yes, according to
Yes.
them.
Yes.
So the petitioner, the informant is not saying that it was a 50%, and 50% was to be paid only on delivery.
On delivery,
So
yes.
what he says about the agreement executed, as per the agreement, 50%, 50%, 100% before delivery.
Lordship.
Could you find anything, or whether the police has seized the agreement executed between the parties?
No,
No, it's not there. And second one, just kindly see also, legal notice he issued demanding for delivery. So he says that it returned saying no person as such found, right?
Lordship, legal notice at which?
Legal notice. So
Where can you find that legal notice?
in his complaint itself,
Yes.
informant, and in the CD also page 2, in the last part
Yes.
of his statement, he has stated legal notice to Mr. So-and-so, and said that it is provided by them that to either deliver the said equipment or return the money within 15 days. But the legal notice returned undelivered, stating that no such person resided at the said address. Now, duty upon the police to seize, because return means it is with him. Whether the police has seized the said,
Lordship.
is there? Is it there?
Not Your Lordship.
Not
Yeah,
there.
Yes.
So two things actually to prove that his allegation is probably may be correct, but that is not there.
But a legal notice will not be an issue now because on the strength of NBWA only he was arrested, Your Lordship.
No, no,
He has been.
no. For the
He-
purpose
he
of considering the bail, whether prima facie there is a case or not, and if this is not
Your
there,
Lordship,
hmm.
admittedly, they have acknowledged that they have received the.
No,
amount.
receive is they have
Lordship.
acknowledged. Now also they are acknowledging. What they are saying is you need to pay. He need to pay 100%.
Yes, Lordship.
What they
That
are
is-
saying is the address given to is not false. So unless this address is false or it was to be paid after delivery, unless that is paid, there is no prima facie case against the accused.
Your Lordship,
Because it was
the
a
term is
civil
50
agreement,
50 only,
agreement,
Your Lordship.
civil nature.
Your Lordship, 50% payment in advance, 50%
No,
at the
no,
time
no,
of delivery.
agreement. What he says about the agreement.
Yes, Your Lordship.
As per the agreement, you have seen in the petition, as per the agreement, he has signed himself. And as per the agreement, if it is correct, if he agree with these terms and conditions, that is payment terms 50% advance, 50% before shipping from China. That is 100% before shipping from China. So if he agree with this agreement that he has executed this agreement, then there is no case, isn't it? Just see page 13.
Yes, yes.
If this is true,
Yes, yes.
and then he need to pay 20% also.
Lordship.
Thereafter only he can say not delivered, if not delivered. So want to obtain instruction or will pass order?
Your Lordship,
Because these things need to be confirmed from
Lordship.
IO, whether during the investigation, whether he has found out, and the allegation is that this address is the address given by this the accused is not correct. That allegation, if it's true, then of course, then also case made out. But then that also, if he has not seized, if he has not sent any legal notice, if it hasn't come back, then the allegation will be false.
Lordship. That in that
Lordship,
case,
may
Lordship, let it
Bridget-
come up on Thursday.
Yes.
Lordship, may I present one aspect of the matter? Lordship, by lodging the petitioner under custody, the complainant will neither get the money nor the assignment will be received. Lordship.
That is true. What I am saying, that is true. True.
Lordship, if there is any breach of agreement, Lordship, that is purely a civil in nature.
So far, no breach of agreement we could see. No? So just confirm if it has come back, if he has seized, or if he has seized the agreement produced by the informant, then only case made out. Otherwise, yes, we will pass order on. When did you say?
Lordship, this case will be disposed of, Lordship,
Thursday.
on the
So
basis of
let us give it. Because this, you see, per se, this agreement seems to be illegal. 50%, 100% delivery, 100% payment before delivery, that is from China. It's not possible. So let us see, let us give an opportunity to trust.
Tomorrow, Lordship, tomorrow.
Tomorrow is will be
Tomorrow is hearing day, I think.
Yes.
So DB, sorry, DB. So single may not seat. So Thursday.
Thursday, Your Lordship.
Okay. You just obtain instruction, and then if they have seized, ask them to produce. This. Okay. Mr. Mr. Watijami, Land Counsel for the petitioner, is present. Stop. Miss Mere, Land PP, submits that although he has received the scanned copy of CD, certain there is certain documents. Some more documents is required to place before this court, and prays that this matter may be listed again on Thursday. Stop. Is prayed. Come on. List this matter on Thursday. The Lana PP, on which date the Lana PP shall produce the updated CD.
Entire reports, Lordship.
Return, huh?
Entire reports.
No, updated CD means the report. Okay.
Obligation.
From the supplementary cost list for motion, item number 19.
But his lordship.
Yes.
Lordship, this contempt of court is arising out of violation of order dated 5th December 2023, passed in the WPC.
Were the respondent represented?
No, Lordship.
Okay, so in the
contempt is respondent number 2 in the WPC 266 and.
In the main case, whether the the respondent was represented.
Yes, Lordship. Respondent number 2.
Okay.
Director of the Tourism Department.
tourism department also appeared
Yes, Lord.
earlier in the main case.
In the main case,
Whether the tourism department appeared before the court.
no,
No.
Lordship.
Okay.
But I have made a party as respondent number 2.
So what is the order
Lordship, in the last
which they have violated? Say, in view of the notice so and so.
dated 5,
Request
12,
petition to
23.
vacate the premises. Status quo.
Yes, Lordship.
So how they have violated?
Lordship, may I take you to page number 14, Annexure C.
Yes.
Lordship, may I read? The undersigned is directed to inform the officer in charge of Tourist Lodge Department not to entertain the guests or tourists from May 2024
So
onward.
the petitioner was running the
Catering service, Lordship, in the
Okay.
Tourist Lodge. Lordship, I'm a lessee, and it is
You-
for
hmm?
lessee. I'm a lessee in the
Okay.
Tourist Lodge for 5 years, from 2020 to 27, and my rights has still not been extinguished, Lordship.
inform the officer in charge of tourist lodging not to entertain the guest. So this is after the passing of the status quo order.
Yes, Lordship. And even in the last order, we were directed to take a fresh steps, and the respondent.
So till then you were running the laws.
Yes, Lordship.
And until then, the guests were entertained in the tourist lodge. Huh?
Lordship, may I take you to Annexure 11, page number 11, Annexure B. In the last order, the government council prayed to file the affidavit in opposition, and I was
Just a minute,
directed to file a fresh petition, to take a fresh steps to respondent number 4.
Yes, yes. So just a minute. Where you have stated that you were running the restaurant catering. Vacate catering.
Lordship, in the paragraph number 2.
So basing on the list, did you have started running the lodge?
Yes, Lordship. Catering service. It's a restaurant, Lordship. I was permitted by the department.
So
for
now
5
now
years.
what is the status? What is the status now?
Now,
You are still running, or
yes, Lordship, I'm still running.
whether the order and the impugn order, the order undersigned is directed to inform office officer in charge tourist laws Dimapur. Who is the officer in charge tourist laws?
It's a senior tourist lodge officer, Lordship.
So he is your employee.
No, Lordship. It's a
Okay.
department, yeah. It's respondent number 3, Lordship.
Huh?
It's respondent number 3 in the writ petition number
No,
266.
but then this tourist lodge is run by you only.
But it's a government. It's a tourist lodge department. This belongs to tourist lodge. This tourist lodge belongs to tourism department,
Yes.
and I'm a lessee for the catering service for the restaurant only.
Hmm.
Before my rights extinguished, they have already entered another list of agreement with the
No,
other.
that is true. Now who is running this tourist lodge? Presently,
Presently, I'm running only the catering service. Catering service.
catering service.
Yes, Lord.
You are doing.
Yes, Lordship. Yes, Lordship.
So whether this order dated this page 14 has affected your
Yes,
services?
Lordship. Yes, Lordship.
How it has affected?
Lordship, the very purpose of not entertaining the guests and tourists in the lodge defeats the purpose of having the tourist.
No. So what I'm asking, my question is whether after this order,
Yes, Lordship.
Your catering service has been affected.
No, it's about to affect, it's about to affect. Since, from the May 2024, they will be taken over by the, respondent number 4, Hotel Polar Towers.
Already taken over.
No, not taken over, not taken over.
Not taken over. You are running.
Yes, Lordship.
My query is whether by this order, 26, okay, this is 26 April. Okay, will me issue notice. So according to you, this order has been passed in violation of the status quo order.
Yes, Lordship.
How it has violated? Just tell me.
It is violating because there is a status quo that both parties has to maintain the status quo.
What is the, what was the status quo?
Status quo, not to hand over the entire land and facilities to the other
That is
entity.
there, but they are not asking you, asking to hand over. They are only not to entertain. How it is, how it affect you? What I'm asking you.
Lordship, if they don't entertain the guests and the tourists in that very lodge, because I'm also the part of the lodge, then the very purpose of having the restraint will be defeated. I'm earning only because of the guests and the customers, Lordship.
This is to okay. Mr.
It's just criminal, Lordship.
Land Council for the petitioner. Stop. Para. The petitioner filed this application under section 11 and 12 of Contempt of Court Act 1971 for willful and deliberate violation of the order dated 5/12/2023, passed in WPC number 266/2023, by which the parties have been directed to maintain a status quo as of date to leave that. No, you should just a minute. Para, leave that part. Okay. Then issue notice. Then issue notice. And let a notice be issued, returnable by
Lordship, after 3 weeks.
3 weeks. Stop. The petitioner shall take steps upon the respondent. How many respondents are there?
So the contender is only one.
No, who is this?
Director,
Is he the one who passed the order?
yes, Lordship.
Upon the respondent by a registered post with AD within 3 days from today, Stop. At least this matter after 3 weeks. Okay. You take steps.
Vice Lord. For orders, item number 16.
Yes, you mentioned this, no?
Lordship.
Okay. So when do you want to say it?
Lordship on 9th May.
9th
May.
May, okay. Mr.
I, Jamil.
Jamil, Learned Counsel for the petitioner. Praise. So the notice also returned unserved, saying that no such person in the address. What do you do? You identify, figure out the
Lordship.
correct address, take
Lordship.
fresh step.
Lordship.
Okay, then we'll say. Then 9th fixing date will not help unless the notice is reached to the respondent.
Lordship, the leading counsel is from Gauhati, so
Maybe, but then inform
yeah, I will.
because it has come
Okay.
back. Okay.
In the meantime, I'll take the steps, necessary steps.
Okay. Jamir, Counsel for the petitioner. Is Mr. Jamir, Counsel for the petitioner. Staff. Also, Miss Mary, this is
Order state.
okay.
Respondent number 1.
Staff. The office note dated 27/3/2024 reflect that notice upon the respondent number 2 has returned unserved with a postal remark on the envelope that no such person in the address. Staff. In view of the above, the Learned Counsel for the petitioner prays for allowing him to take fresh steps upon the respondent number 2. Step be taken within a week from today. List this matter after
Lordship, a fixed date on 9th
9th
May.
May, April, May, 9th May, will it reach? This is last part of April. 9th May, it will not reach because you will have to take steps. It will not reach. Inform the Learned Counsel
Lordship.
at Gauhati that since no point listing the prior
Lordship,
before
then,
that, isn't it?
Lordship on 20, then on 20th.
20.
Lordship.
Okay. Is prayed for by the Learned Counsel for the petition. List this matter on 20. Okay.
Obliged, Lordship.
20 May,
For orders, item number 17.
May it please your lordship.
Yes.
Lordship, though the matter is at the order stage, since the parties are duly represented, if this matter can be taken up today, lordship. If this matter can be taken up for hearing, since the parties are duly represented, lordship.
Okay.
Lordship,
Can be taken up. Okay. What is this matter about?
lordship, this instant a criminal petition is filed for
Criminal
quashing,
petition.
lordship. Basing on the undertaking given by the complainant and also the compromise agreement by between the accused and the with
Is it
victim.
quashing petition?
Yes, lordship. Lordship, the FIR is at Annexure A, page 10, lordship.
Okay. FRA page
Page 10, Annexure A.
just a minute. Sir. Okay. Yes.
So, lordship, may I read the FIR?
Yes,
Lordship?
please.
To the officer in charge, Simni Police Station, Simni, Nagaland.
Subject registration of FIR information report against the youth from Tsingniu village and town. As stated above, I would like to bring your notice that on 6/11/2015, some youths from Tsingniu village and town numbering about 10 to 15, all in the inhabited condition under the banner of Tsingniu Youth Organization, geared my office and physically manhandled some deposits on duty within the office premises in utter disregard to this very important public institution, thus hurting the sentiment of the employees and the public enclosed in the representation both by the TVYO for submission to the ADC Tsingniu, during which they created such an ugly scene in the office premises. Based on the incident mentioned above, I request you to register an FIR against the person at the earliest lodge. So, Lordship, that was the complaint filed by the respondent number 2. That is the complainant, Lordship.
So the informed
Lordship.
is additional DC.
Yes, Lordship. The then ADC, Lordship. So, Lordship, the FIO was registered, Lordship. That is Annexure A1, Lordship. And they were booked, initially they were booked under section 353, 325, 450, 307, and 34 IPC, Lordship. So, Lordship, here, while the investigation was going on, some of the accused persons were discharged, Lordship. Some of the accused persons were discharged.
Discharged during
the investigation, Lordship. So
how during the investigation discharged?
9 of them were arrested, Lordship, initially when the FIR was lodged. So the accused person, the name of the accused persons are here, Lordship, at page 11, Annexure A1, Lordship. Page 11.
Page 11 is?
That is the FIR. 9 of the accused persons were registered here, Lordship.
Okay, so the register is against 9 of them.
Yes, Lordship.
So,
and while the charge sheet was filed, Lordship.
Charge sheet already filed?
Yes, Lordship.
Yes,
against the 4 of them, Lordship.
Only against 4 of them?
Yes, Lordship.
So during investigation, 9 accused persons were arrested.
Lordship.
Then at the time of filing charge sheet, only against 4.
Yes, Lordship.
Found for commission of what offense?
Lordship, the charge sheet is the type copy is at page 22, Lordship. If my Lord may
Page
22. That is the type copy.
Yes.
So, Lordship, here
325.
Lordship, 325, 450, 307, and 334 IPC, Lordship.
This is not compoundable.
Lordship, though it's not compoundable, the High Court has the inherent power under 482, Lordship.
Now 307, you see.
Yes, Lordship.
Register under 307. That is also on the basis of the information given by the ADC, the responsible officer of the state.
Lordship. However, Lordship, there was no injury. That 307, that is the second part, Lordship. There was no injury, Lordship, and in fact, there is no medical document to support the allegation that it was 307, Lordship. In fact, I have the citations to support my submission.
Then, if there is nothing, then you pray at the time of hearing on the charge.
Lordship,
at the time of framing charge.
Obviously, I did, Lordship. However, they did not consider it while altering the charge, Lordship. That was they said they will see only at the time of argument. That is why we have a
so because the case has already been charge sheeted.
Lordship.
So now you have an opportunity.
Lordship.
Because
in fact, however, Lordship,
interference.
Yes, Lordship, but
because
I have the compromised date, Lordship.
It is not a case that where there is no prima facie case. The responsible officer, ADC, has lodged complaint.
Lordship, that was because there was some mutes. That was not the actual. In fact, Lordship, if my Lord may kindly see the real genesis of this case, Lordship. That is, we have stated everything in the compromise agreement, Lordship. The present case erupted because of the other issues, in fact, Lordship. That is, however, the FIR was filed only after there was the youth, the office of the
whatever maybe, you see 325
Lordship
and 307.
Lordship.
See, then how the 325 offense under 325 can come unless there is an injury?
Lordship, that is just the case of the prosecution,
No, it
Lordship.
will be difficult, little difficult.
Lordship, I have the citations also for that.
And the
Lordship.
compromise petition, who entered?
Lordship, the compromise is entered between the accused and the victims, Lordship.
Accused and the
Victims, Lordship.
victim.
Yes, and in fact, the
What about the ADC who lost?
yes, she has given the undertaking also. Like I have an access an
No.
extensive.
He is a aggrieved person.
No, Lordship. If my Lord may kindly see the annexure C, Lordship. She was annexure C of my annexure, Lordship.
What is this? What is
It's an
annexure C?
undertaking given by the ADC, Lordship, the then ADC, the complainant, Lordship. May I read, Lordship?
Yes, please.
To whom it may concern, no objection. In reference to Tsimneo police case number 06 of 15 corresponding to GR number 328 of 15 under section 325 450 307 34 IPC, it is mentioned that I am the complainant in the instant case and that I have no objection if both the victim and the accused persons are ready to compromise the matter for compounding the offences. The instant case is pending before the Honourable Court in Kohima, and as such, the matter may be educated as per the prevailing law in the interest of all the parties and in the rest of justice.
See, the instant case pending so and so. The matter may be adjudicated as per the prevailing law in the interest of all the parties.
She, Lordship, that is not what she meant, Lordship. In fact, the complainant has also filed their affidavit stating they have no objection to closing this instant case, Lordship.
Yeah, you are representing?
My lord, I'm for the complainant.
Complainant?
Yes, my lord.
ADC?
Yes, my lord. And only this morning I filed my affidavit in opposition. But I think so it's not reached here yet.
Oh, you have filed affidavit in
Yes,
opposition?
maybe
So not
with the
reached?
district.
No, not.
Just this morning, yes.
So,
My lord, in this case, if the accused and the victim, they have already compromised the matter, then I don't have any objection if the criminal proceedings are passed. In the larger interest of the community of the Tsimneo public and also for the well-being and the peaceful coexistence of the accused and the victims. I don't have any objection if the criminal proceedings are passed.
So you are for the informant as well as the accused, sorry, not for the accused.
No, I'm for the.
Okay, so no, sorry, no, the victim, who represent victim?
Lordship, we have not, Lordship, report has not been called for. Without seeing the report, Lordship, at this.
The record also not called for?
No.
No, record need to be seen.
Yes. First.
I thought that parties are present and records are also there. And then you have also filed affidavit. So what do? We can fix another date.
Lordship.
Okay, I think because ADC is not the person who was injured.
No, Lordship.
He just
the complainant.
He is just a complainant. But then thereafter, the ADC, the complainant, the informant says, even if the informant says have no problem if the parties, the accused and the aggrieved, the injured persons enter into agreement or they settle the matter out of court.
Lordship,
so the victim also probably, no?
The victim has signed the compromise deed.
No, so have you implemented the victim also?
Oh no, Lordship, since we are asked to implement only the complainant.
How many victims are there?
In fact, there is just one, Lordship.
Because here, he, in the official capacity, he has just filed complaint. So, but the main aggrieved is the victim, and probably the consent of the victim is necessary. Okay.
Lordship, in that case, I have no issue in implementing the victim, Lordship. If I'll file the IA for implement, Lordship.
That will be better, because if the victim says, come and says, we have no problem, and then since complainant has no problem, and if in the records, if we don't find as you submitted anything or incriminating materials against the accused, and then if this 325 is otherwise, you see, it's trouble.
They are charged under 307 and it's non-bailable.
307.
Yes.
So we'll have to see the records also. Okay. Ms. Mikaich. I Lana counsel for the petitioner. Also heard Ms. Mary Lana KP and Mr. A. Sophie Malo. Okay. Land Council for the respondent number two. Stop. Okay. In this case, the record of the record of the case from the trial court would be necessary to consider for proper adjudication of the case. Also, the victim need to be included as a respondent party. Stop. At this, Ms. Mika, HL, Land Council for the petitioner submitted a praise for some time to include the victim as respondent and respondent party. Stop. The prayer is allowed. List is matter after 3 weeks. In the meantime, Ms. Mere, Lana PP shall also produce the.
Since it's charge sheeted, let the LCR be called, Your Lordship.
Okay.
Yes.
Sorry, charge sheeted.
Yes.
It is then before the CJM only.
Yes.
Okay. Call for the LCR. Okay.
Lordship, interim may continue, Lordship.
There is interim.
Yes, Lordship.
What is the interim?
GR has been stayed.
State till the next returnable date, Lordship.
Considering the nature of okay. In the meantime, the interim order pass on 1/4/2024 shall continue till the next date. Okay.
Much obliged, Lordship.
For hearing item number 20.
Please, Your Lordship.
Yes.
Hearing has almost been concluded. I was directed to file an additional affidavit. Yes, which I filed it on Friday.
Okay.
I hope it is in place on records. If Your Lordship have the additional affidavit, the page number 3 of the additional affidavit will be relevant, which has to be brought to the knowledge of this honorable court, and I was directed to file by way of an additional affidavit, this office memorandum.
Yes.
And this has protected the rights of the landowners. When it comes to appointment on the ground of a compassionate appointment or landowner, the advertisement has been dispensed with, meaning which that no advertisement is required when appointments are done on compassionate appointment and land ownership. And one of the prayers made by the petitioners in the petition is to advertise the post which I am appointed. So I think with this office memorandum, the prayer is defeated, Your Lordship. One of the prayers in the petition is to advertise the post which I'm holding.
Your Lordship, the OM dated 3 March 2022, filed by the respondent, will not be applicable in the present case, Your Lordship, because
So-
appointment on the basis of land ownership has
already been availed, Your Lordship.
Presence of? Just a minute. So this notification 3/2022 is not?
Is not applicable in the present case, Your Lordship. Your Lordship, appointment on the basis of land ownership has been availed. Your Lordship, the post held by the respondent number 5 is not to be filled on land ownership, Your Lordship. It's a public post. Your Lordship, the notification which I have annexed in the writ petition as Annexure I provides for only one-time appointment.
One-time appointment.
Yes, Your Lordship.
Notification, which one?
Annexure I, page number
47, Your Lordship.
Is
page 47
47.
to the writ petition.
Where it is said?
Your Lordship, can you please refer to clause 2? Page
Clause
48, clause 2.
Close to.
Your Lordship, it is clearly stated that all cases.
Just a minute. Page 47, close to. Close to is?
Page 48, it will be page 48.
Yes,
Close to
48.
the-
Yes, where?
All cases where administrative headquarters and block headquarters were set up in various parts of the state on lands donated freely by individuals, villages, or people of that area should not be reopened for compensation or for employment in consonance with the policy brought out right memorandum number such and such dated 26/1977. Clause 3A, Your Lordship, in other cases prior to 26/7/2005 and subsequent to setting up of administrative and block headquarters on freely donated land where a specific written agreement exists providing for employment to the landowner, the claim for employment should be settled in terms of such agreement, Your Lordship. Clause 3, subclause B. If there is any claim for providing employment as a result of oral agreement, the department concerned shall refer the matter to the Deputy Commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or other facility, including contract or supply order, has been given in the past. Written statements from the witnesses, that is government officials of the concerned department and the district administration and village functionaries present at the time of such oral agreement should be taken by the Deputy Commissioner. The recommendation of the Deputy Commissioner should be referred with relevant documents to the Department of Land Revenue for advice in such cases by the department concerned. Clause 3, subclause C. Your Lordship, it is also clearly clarified that it is not the policy of the government to provide employment to the landowner in perpetuity. The employment of landowner, if permitted by a verifiable and valid agreement, is limited to the person first appointed as landowner in government service and does not entitle his descendants for further employment, Your Lordship.
Okay, but so this notification is dated?
It's dated 5/3, 2020.
18. So,
and Your Lordship, the agreement between the land was.
Just a minute, huh? Take just the submission of the land account, one submission, huh? Later on, rest will. Your submission is that the advertisement is not required.
Advertisement is not required, and one of the pertinent issues raised by this court on the last date of hearing is
Okay,
this particular
okay, please.
This particular notification which the petitioner is relying, 5th March 2018. 5th March 2018 is not applicable in my case because I was appointed in 8 August 2014, Your Lordship. Prior to the policy enforcement of this notification.
Okay.
So it
Yeah.
will not have a retrospective
Okay,
effect.
the Land Council for the petitioner submits. This will be your submission, huh? Submits that in view of the government of Nagaland notification dated 5/3/2018, where it says that where in point number 3A and then 2, where the notification number 2C, it says that inverted comma 3C, 3C. It is also clarified that it is not the policy of the government to provide employment to the landowner in perpetuity. The employment of landowner, if permitted by a verifiable and valid agreement, is limited to a person first appointed as landowner in government service and does not entitle his descendant for further employment on his retirement from service. Stop. After the appointment, landowner retires or vacates the post, the vacancy will be filled up through open advertisement in consonance with the existing policy, giving equal opportunity to all applicant. Inverted comma clause. Stop. In view of the above notification, the respondent number,
Respondent number 5.
private respondent number 5 could not have been appointed by the respondent authority. And as such, the appointment of the respondent number 5 is in violation of the said notification dated 5/3/2018. Stop. Next para. The Land Council for the respondent number 5 submits that the notification dated 5/3/2018 is not applicable in respect of the petitioner in as much as the petitioner in as much as the respondent number 5 was appointed when
8 August 2014, Your Lordship.
on 8 August 2014,
7 August, Your Lordship.
7/8/2014, prior to the issuance of the above notification dated 5/3/2018. Stop. Moreover, further, by office memorandum number AR-3/GEN, capital GEN -174 /2007 within bracket part PT, bracket close, dated 3 March 2022. The the government has clarified the procedure regarding filling up of grade 4 post in the government. Sorry, just a minute. By last part, leave, dated 3 March 2022. Under subject filling up of Group D post in the departments, there's corrigendum issued regarding the regarding the said regarding stop the said notification is for better understanding the said notification is you have to type this, okay? Reproduce here in below, huh? You have to type from the para 2 up to 2, okay? Yes. Annexure A of the affidavit, huh? Page 3, annexure A, page 3 of the additional affidavit filed by the petitioner, huh? Okay. Then down below, in view of the above notification, the advertisement to the post against which the respondent number 5 was appointed is not required. Was not required, huh? Okay. Yes. What is your other submission?
Your Lordship, this notification, 5th March 2028, 2018 will have a retrospective effect.
Retrospective? Where
Your
to
Lordship,
find?
it is clearly stated in the notification that,
Where?
Your Lordship, can you please refer to clause 1, A. An extra
Clause 1, A.
Your Lordship,
Yes.
it has been laid down by notification dated number such and such dated 26/7/2005 that no land shall be acquired free of cost, and all land shall be acquired on payment of full compensation as determined by law. No further condition for employment in service or contractual work should be entertained. Therefore, in case any department has entered into any agreement shall be treated as null and void. The department concerned shall take necessary action accordingly to nullify such agreement. In case the department concerned is of the view that the agreement should not be declared null and void, it shall refer it to relevant details giving justification to the Department of Land Revenue for examination and advice in consultation with PNAR and Justice and Law Department, and thereafter submit the matter for consideration and decision of the cabinet. Your Lordship, as stated earlier, clause 3A, it speaks about prior to 26/7/2005 in cases. In cases prior to 2005, if any written agreement or oral agreement is there, for that some exception are there. But after 2005, this notification
shall be acquired.
this notification has to be followed. And Your Lordship, the land was donated in the year 2009.
2000?
2009.
No.
2009, Your Lordship, can you please?
2009.
Yes, Your Lordship. Can you please refer to the affidavit in opposition
It has
filed
been
by the
laid down that
respondent number 5?
no land shall be acquired free of cost. All land shall be acquired on payment of full compensation as determined by law. No further condition. Implement in service or contractual work should be extended. But in case any department is included in agreement, shall be treated as non-agreement. The department concerns will take necessary action within the narrative section. Compared to the department implemented review, the agreement should not significantly it's a level of relevant details in within justification to the department of land of the general and of rights in constitution which we have in the states. So there is also one in this 3A, just see 3A of the 2005 notification. In other case, prior to, okay, this is prior to, okay, 2005, and subsequent to setting up of administrative and block headquarters on freely donated land, where a specific written agreement exists providing for employment to the landowner, the claim for employment should be settled in terms of such agreement. So this is talking about the prior to 2005. So, but here in the present case, the appointment was in the 2014.
Yes, Your Lordship, but my proposition to this is, this law was enforced only on 5th March 2018.
Yes.
I was appointed in 2014.
No.
So how
No.
can I violate the law
Just read,
which is non-existent, Your Lordship?
Just read 1A.
Yes, Your Lordship.
1A, kindly read 1A. Just read it. Read it once.
It has been laid down that by notification number so-and-so dated 26/7/2005 that no land shall be acquired free of cost and all land shall be acquired on payment of full compensation as determined by law. No further conditions to employment and service on contractual work should be entertained. Therefore, in any case of department has entered to any agreement shall be treated as null and void.
Treated as null and void.
Your Lordship, in that case, the petitioner has also availed one appointment on land ownership basis. Even including the petitioner, Your Lordship, he was also one of the landowners. So in that case, his appointment also becomes illegal, Your Lordship. That has to be taken into consideration.
No, that has not been noticed, not before us.
But that will amount to suppression itself, the petition, Your Lordship, suppression of the facts.
Just
Because
no.
the law is clear.
So as per this, you see, so this in the 2018, and it says that it has been laid down in 2015, referring to the 2005, that no land shall be acquired.
This order was issued only in 2018, Your Lordship. It was enforced.
Yeah.
So I cannot violate a law which was not existent at the time of my appointment.
No, just see. You have just read. No further condition for employment and service or contractual work should be entertained. Therefore, in case any department has entertained, kindly see, turn to next page. Any agreement shall be, so entertain into any agreement shall be treated as null and void, even if thereafter also, if any department entered into such agreement, shall be treated as null and void.
In that case, Your Lordship, the petitioner himself has availed one of the opportunity. That this particular was not their grounds, these particular provisions of law. That is not the grounds in this petition. This petition be dismissed on suppression, and then they can file another fresh petition, Your Lordship.
Department concerned shall take necessary action according to action accordingly to nullify such agreement.
And it was enforced. This particular decision, the notification was enforced on 2018, 5th March 2018.
So that is right. That is why.
So declaring null and void under clause 1A, Your Lordship, it came into existence only in 5th March 2018, Your Lordship.
No, it is referring to.
That has to be accounted, Your Lordship.
Just see 1A referring to it has been laid down. It has already been laid down in the year 2005. Notification 2005 also, that no land shall be acquired free of cost, and all land shall be acquired on payment of full compensation as determined by law. No further condition for employment. No further condition for employment in service or contractual work should be entertained. The 2005 says. Therefore, in case any department has entered into any agreement, shall be treated as null and void.
And Your Lordship, the respondent number 5, they are not the landowner, Your Lordship. They are not the landowner.
Landowner, that this court may not be, of course, entered into to declare who is the landowner, because that has been, of course, Dabasis has declared.
Yes.
So he and you both are the owner, both are entitled.
Before
if entitled.
The history about appointment of land ownership, Your Lordship, once a land has been donated free of cost, before the enforcement of the 5th March 2018 notification, Your Lordship, there was no limit for the landowners to get appointed. Multiple appointments can be made under in grade 4 post, Your Lordship. So the government has introduced a new policy decision by way of the 5th March 2018.
Any decision thereafter, appointment thereafter, and then
no, to my knowledge, so far not, sir, Your Lordship. So after 5th March 2018, that has come into force, there can be only one appointment. Otherwise,
5th March
2018, that is the present notification which we are concerned with.
So during not 18, prior to 18.
Prior to 18,
after 2005.
After 18, there is only one appointment on the basis of land ownership.
This is not after 18, it's prior to 18.
prior to 18, there was no
See,
limit.
He was appointed in the year 2014 only.
Yes, Your Lordship. So there was no limit for the appointment of land ownership. It can be 10, it can be 20, Your Lordship. So government came to a policy decision by way of this 5th March 2018 and made it clear that only one appointment will be made on the basis of land ownership.
And that is after 2018 only.
Yes, 2018 only. So
But
we have all donated the land. They got one appointment, I got one appointment, Your Lordship. But after that, so far, to my knowledge, I don't think anyone has been appointed subsequent to the 5th March 2018 notification.
But this notification 2018, which refer to 2005,
Yes, Your Lordship.
says that from 2005 onwards, 5 only, says that no further condition for employment service, and if any agreement shall, and if the department has entered into any agreement, shall be treated as null and void. So whether after 2018 and between 2005 and 2018, has there been any appointment on the land ownership basis?
Pardon, Your Lordship.
2000 in between 2005 and 18.
2005 and 18. I was appointed, Your Lordship. And
No, other than you.
the petitioner was also one of the petitioners. They were also
How many
appointed
petitioners
from the landowners, because from this land one was appointed.
Only one petitioner. Petitioner was not appointed.
No, but from one of his relatives, likely which was already withdrawn, Your Lordship. State councils. They have already claimed their appointment, Your Lordship, which the state can produce, I think.
Now, see the
Your Lordship, since the appointment on the basis of land ownership has been ever, the earlier writ petition was withdrawn. The reason for withdrawing the earlier writ petition was for this reason, because Your Lordship, the land which was donated by my grandfather, the land was already divided during the lifetime of the great grandfather. So they are not entitled to be appointed on the said land. Even the village council had clarified about the land.
where is the statement that during or prior to this 18 also it was illegal and the department could not have appointed. Have you stated anywhere in your petition?
No, Your Lordship, I haven't stated.
So this notification is only after 2018. So prior to date, because the petitioner was, sorry, the respondent number 5 was appointed in the year 2014 only. So 2014 is on the appointment of the respondent number 5 in the year 2014 on the land ownership basis. Where have you stated that this is also illegal?
It is not the pleaded case of the petitioner, Your Lordship. It is not the pleaded case of the petition in that particular government.
Because this you have pointed out, and this you have pointed out now. This should have been pleaded in your petition, that in between these 2005 and 18 also could not have appointed. Where have you pleaded?
No, Your Lordship, I haven't made the statement. I've just annexed the notification. And passing on this, my earlier petition was withdrawn. Because if the post held by the respondent number 5 has to be filled on the basis of land ownership, I have better right than him to be appointed because I'm the rightful landowner of the present land.
I'm saying that on prior to 18, in between 2005 and 18, has there been any appointment?
I don't think, to my knowledge, Your Lordship.
Only you?
Yes, Your Lordship.
Because as per this, then any agreement entered shall be treated as null and void.
When there is only one agreement that is already under challenge, Your Lordship. I was the only one appointed. And that too, my appointment has been challenged. I don't think there will be other subsequent appointments.
No, not subsequent. During this period.
Besides that count, Your Lordship, one of the technical aspects in the petition is it is not the pleaded case of the petitioner that this has been violated. Second thing is my approval order has not been challenged, Your Lordship, which has already been laid down by the Supreme Court. So on technical aspect itself, this petition has to be dismissed. And once a petition is to be dismissed on the
No, just you see. So this notification, since he has already pointed out that this notification, and then the clause 1A, clause 1B, he is also right. If you have not pleaded this, who would have actually pleaded? Because the pleadings of the respondent number 5 is that this 2018 came into force only after his appointment in the year 2014. And then subsequently, during those periods, so if the appointment is made on the landowner basis, the post cannot be, that is exempted. The advertisement is exempted. So if this is not your pleading, can we go beyond the pleadings also? Can we give the relief beyond pleading?
Your Lordship, the present petition is filed challenging the appointment on the basis of his appointment is illegal, as the respondent authority has appointed without following due.
No, this and then the office notification 26/7/2005. Have you annexed that?
No, Your Lordship.
That also is not there.
But Your Lordship, it's clearly reflected in the notification 5/3/2008, the notification of 2005.
I think we need some further clarification in this regard. Because earlier, on that day, so this was not pleaded on that day by you also.
So, Your Lordship, I think it's almost settled.
Now,
Meetings-
can we neglect also? Can we neglect
Your
also?
Lordship, but they still have the liberty, Your Lordship. Either to withdraw, dismiss the petition, they can file a fresh petition, Your Lordship.
It's
And
Additional,
pleadings are a bundle of facts, which helps the courts in molding the relief. And without that, that's a basic fundamental, Your Lordship. So how can a court decide an issue which was not raised to the court, Your Lordship?
But your lordship, the respondent number 5 is not a landowner, your lordship, and his appointment has a landowner cannot be sustained.
no, he,
So, Your Lordship, these issues may not be dealt in this petition, but the liberty has not been exhausted in a fresh petition, Your Lordship.
this annexer J, this is annexer J. And then there you kindly read this annexer where you have annexer J, K, page 7.
A similar petition has been withdrawn by the petitioner because in that particular petition, they would not have entertained the prayer, Your Lordship. So the petitioner had to withdraw the petition. So again, the same error has been committed in this petition. So they will either they have to withdraw or dismiss the petition, Your Lordship.
Just read your
And it's well understood.
2K, page 7.
Yes, your
Kindly,
lordship.
read.
Uh,
Because this is your pleading, huh?
Yes,
Just see.
that the petitioner states that one Srimati Tushimila was appointed to the post of medical attendant under PHC Yongwon. It was the case of the respondents that the present petitioner cannot be appointed to the post of medical attendant at PHC Yongwon on the basis of land ownership, as appointment on the basis of land ownership is limited to the person first appointed. Therefore, by order dated 28 June 2019, this honorable court was pleased to allow the petitioner to withdraw the writ petition with the liberty to file afresh.
Okay, this is, no, this is withdrawal. What is this? Oh,
Page 50
not
is the
J,
next
not
Your
J,
Lordship.
not J. This is I. Just a minute, huh? Sorry, I, prior to that, before that, a paragraph before that, just J, not K, J. This is your pleading, huh?
Okay. That during the pendency of WPC number 117K of 2015, the state government-wide notification dated 5/3/2018 frame a policy with regard to appointments to grade 4 posts under the government of Nagaland on land ownership basis. Clause 3, subclause C of the said notification clearly lays down that the employment of landowner if permitted by a verifiable and valid agreement, is limited to the person first appointed as landowner in government service and does not entitle his descendants for further employment on his retirement from service. After the appointed landowner retires or vacates the post, the vacancy will be filled up through open advertisement in consonance with the existing policy, giving equal opportunity to all applicants.
So here you have pointed out 3C.
Pardon, Your Worship.
Your pleading is 3C.
Yes.
You have not pointed out, or it's not your pleading, that the prior to date also, if the person is appointed on the land ownership basis, it will be nullified, null and void. It is not your pleaded case.
Yes, Your Worship.
What is submitting? So 3C is, now let us read 3C also, page 49. Your pleaded case.
It is also clarified that it is not the policy of the government to provide employment to the landowners,
Yes.
in perpetuity.
Yes.
The employment of landowner, if permitted by a verifiable and valid agreement, is limited to the person first appointed as landowner in government service and does not entitle his descendants for further employment on his retirement from service. After the appointed landowner retires or vacates the post, the vacancy will be filled up through open advertisement in consonance with the existing policy, giving equal opportunity to all applicants.
So this is your pleaded case.
Yes.
Yes, Your Worship. Your Worship, if this notification was not notified, I shouldn't have returned the earlier petition because these notifications provides for only one-time appointment, so I have to withdraw the earlier case.
Which is also prospective in nature, Your Lordship. So it got enforced only in 5th March 2018. So the reason for withdrawing a petition, the first petition, Your Lordship, that particular issue could not have been dealt in that petition. So the petitioner withdrew that, and then again they filed this present writ petition and raising an issue which could not have been dealt in this present petition, Your Lordship.
This notification was brought to the notice of the court, and accordingly, I've returned this writ petition, the earlier writ petition. Was the earlier petition was filed challenging the appointment of the respondent number 5, as well as claiming appointment on the basis of land ownership, because I am the original and the rightful landowner. They have got the appointment up because they have submitted forged land ownership certificate. And regarding the issue, we have submitted several application representations to the department.
So because you're pleading on the basis of your pleading only, it will be recorded. Where have you disputed the land that stated that the respondent number 5 is not the land owner? Where have you stated?
Your Lordship, that will be again a disputed question of fact.
No. So
affecting my title
this is
again.
basing on that.
Again,
The disputed of case
into that.
where
Your
just
Worship,
where she has stated.
that statement I haven't I didn't make any statement regarding that.
Okay, so then
Because,
your
Your
submission.
Lordship, I have annexed the earlier writ petition. After it's stated.
Earlier read petition,
Yes, Your Lordship, it's annexed.
read petition filed before the court, you have annexed the read petition itself.
Yes, Your Lordship. Annexure I, page number 22.
Okay.
And Your Lordship, I have filed a additional affidavit also, Your Lordship. Regarding repeating the land ownership of the respondent number 5. Your Lordship, can you please refer to the additional affidavit? Additional affidavit, I have filed an additional affidavit.
In earlier petition,
No, Your Lordship, recently I filed it.
recently. What is there?
Your Lordship, this matter was heard before last year, and this honorable court has directed me to file an affidavit repeating the land ownership of the respondent number 5. Accordingly, I filed the additional affidavit.
Additional affidavit.
Yes, Your Lordship.
Okay,
In compliance to the honorable court order dated 30/10/2023.
so what you have stated there in the additional affidavit?
Your Lordship, can you please, para 3. That the petitioner respectfully states that the respondent number 5 was appointed to the said post of medical attendant by the respondent authority on the basis of forged land ownership certificate submitted along with his application for appointment. Para 4. That along with the land ownership certification, the respondent number 5 had annexed a no objection certificate dated 21/8/2013, signed on behalf of the landowners, namely Shri Aunoklan, Shri Shilumayang, and Shri Tsuknong Timjin, certifying and recommending the respondent number 5 for the appointment of medical attendant against the post vacated by the retirement of Shri Imnitim Shri, Your Lordship. While submitting their application for appointment, they have annexed a no objection certificate. They have obtained the signature of 3 persons, Your Lordship, but the 3 signee, they have given their statement stating that they are not the landowner. Your Lordship, that document I have annexed to
Whether those persons filed FIR against that?
No, they have I think they have a case in the village.
They have a?
Because they have forged the land ownership certificate, and the village council recommendation of the village council was also forged. So the landowner, the village council, they have held a meeting, and
Whether
they were
against
punished for
the
that.
full document submitted by the respondent number 5, whether this person has lost FIR?
No, Your Lordship. But the complaint was forwarded to the village council and to the department also.
Immediately, the petitioner should have lodged an FIR because it's a case of forgery, as per the allegation, Your Lordship. And it will take some experts to identify whether it is a case of forgery or not. And then the petitioners are relying on an additional affidavit. To counter that, the law has already been settled by the Supreme Court in Mohinder Singh's Gill's case. I think it is being decided reported in 1975, Your Lordship. And if I'm not mistaken, it has been affirmed in paragraph 8, Your Lordship, that by way of an affidavit, you cannot improvise your case. And the Supreme Court has been upholding the judgment till date, Your Lordship. So it's a pure case of improvising a case by filing an affidavit. So affidavits are not pleaded cases, Your Lordship.
So what is the affidavit in opposition for respondent number 1, 2, 3, and 4?
That's evident.
My lord, in the earlier occasion, I've made my submission that private respondent number 5 was appointed on the land ownership basis. Basing on the documents furnished by the respondent number 5, state has taken state has considered this case. And
So-
in the case of the petitioner,
What do you say about this notification just pointed out by the land council for the petitioner about the 2018 notification where it referred that 2000, in the year 2005, where it said that if the land, no land shall be acquired free of cost, and all land shall be acquired on payment of full pay compensation as determined by law. No further condition for employment in service of or contractual work should be entertained. Therefore, in any case, in case any department has entered into any agreement, shall be treated as null and void. So if this is in existence, this 2005 notification, so on the basis of land ownership, you could not have appointed. If
Yes.
this was in existence.
but
So
my
this
lord,
2018 is subsequent notification.
in that regard, my lord, in the pleadings, since the petitioner has not contended or made any arguments, that is why state could not get opportunity to explain. Otherwise, if it is in the argument, then the state should have given a justification, my lord.
So we'll be needing that because this is not in the pleadings.
Yes,
This is not in your pleadings.
It's not a pleading.
Even if it is not in the pleadings, if it is annexed, if it can be incorporated, if it can be taken into account, if
No,
you have any power.
No, your lordship, this has already been laid down. That means
So-
to file an affidavit.
So she has also filed by filing affidavit also, and by way of oral submission also she has made that this pointed out, and then if there is any power against this, then you
To
submit.
counter that, your lordship, it is a settled law by the Supreme Court. I think it is in 1978. Mohinder Singh's case. Yes.
You
I can place the judgment, your
you
lordship.
place the judgment.
One
also.
cannot improvise the case by way of an affidavit.
Hmm.
That is a laid down law passed by a constitutional bench of the Supreme Court, your lordship.
Hmm.
And it has been reiterated in almost all in so many cases of the High Court as well as by the Supreme Court, your lordship. So the paragraph will be 8, I think. Mohinder Singh's case.
Yes, yes. You place the judgment also,
My lord,
and then
even in the affidavit in the reply also, yes, she has not met that requirement.
Yes.
Even in the affidavit in reply.
So it's just a mere case.
But then there is a notification, you see, standing notification.
Yes, standing notification.
But there is a standing notification which says with debar from appointment.
That is
And then now she is submitting that on the basis of that notification, she has withdrawn the earlier writ petition.
but that is not a subject matter raised by the petitioner in this present case, your lordship.
So because under the circumstances, now since there is a documents before this court, and if you are aggrieved or if you think that there is a this cannot be taken into account, you file the submit the
The only issue,
citation.
yes, the only issue is whether the issues raised by the petition can be decided by this court or not. Because if it is not a pleaded case, and pleadings are a bundle of facts raised by the litigants for the court to be decided, your lordship.
Right.
And you cannot go beyond the pleadings, your lordship, be it the respondent, any parties, your lordship. So in this case, whether a petition of this nature is entertainable by this court or not, that will be one of the substantial question of law to be answered.
So now what I will be needing is I will be needing a written submission now.
Yes, your lordship.
With the citation.
Yes, your lordship.
Because now you have pointed out which is not under which is not in your pleadings. You have pointed out certain things, and certain things you have come back or come along with by way of filing affidavit. So you also submit written submission. So you
Yes,
your side also.
Yes, your lordship.
Okay, both also. So that because now before the court is this 2005 notification is also there. So if the 2005 is in subsistence, or if it is during the existence of this 2005 notification, then the respondent could not have appointed. The state respondent could not have appointed the respondent number 5. And subsequently, this 2018 notification comes. And then what she is submitting, although not in the pleadings, but then she has annexed the notification saying that if the respondent authority anyone does, it will be null and void only. So it is not in her pleading, but then it is in a notification. Now you have to satisfy the court that although it is not in your pleadings, it has to be taken into account. So if there is a ruling, if there is a citation, you also place. So otherwise, otherwise the court, on being pointed out, whether the court should take account of it or not. So when can you file? Friday or when?
Friday, Your Lordship, because this constitution won't be available next week, probably, Your Lordship. So
I have no idea.
we can
It
conclude.
may be available also.
Yes, but
The
it's
notification
uncertain.
has not yet come.
Yes.
But then in any case, it will be placed before this court only because I have
Yes.
heard an entire thing. So what we'll do is we'll be keep it as a part heard only. So it will be listed Friday if you are ready. If Friday not ready also, then it will be listed before this court only.
We don't have to argue. We only have to place the written arguments.
Written argument,
Yes.
place it, but then
So-
we'll keep it as a part heard
Yes.
only.
Yes.
So unless it is, I'm satisfied that the entire thing has been with this court, then I cannot keep it as a CAB also.
Yes.
Only keep it as a part heard only.
Only for submission of our written arguments.
Written argument.
Those verbal arguments are over.
My lord,
If there is any additional submission,
yes.
you can also place, huh?
My lord, state will rely on the affidavit filed by.
Okay. Pardon me, sir. This was in the stand adjourned for today. Okay. Miss Imna Sangla, counsel for the petitioner, also heard Mr. A. Tibum Pom,
Yes, lord.
Tibum Pom, government advocate for the state. Respondent, huh? And I also Mr.
I intend, Your Lordship.
I intend land counsel for the respondent number 5 staff. List this matter again on Friday, for further hearing. On which date the land counsel for the party shall submit, also submit written argument. Okay.
Much obliged.
Oh no, your affidavit, has it been brought into?
Yes,
in the
additional
order? Has
affidavit.
it come?
Yes, yes, Your Lordship. It is
Okay,
brought on
you have received
record.
the additional affidavit. Okay, that's fine. Okay.
Much obliged, Your Lordship.